Right, hello, good morning. Thank you very much for joining us for our Developing Greenfield Sites webinar this morning. This is part of a series of cornerstone webinars from our planning team. And we've got one a little bit later this week on the 27th of May called Planning for Schools. We have one on the 7th of June about compulsory purchase orders, and then one on the 21st of June wrapping up all the case law that's occurred this year. So well worth signing up for those as well. Joining me today is Jonathan Clay and Rowan Clapp. Jonathan, Rowan and me are barristers specialising in planning and environment law, and we all have experience in planning inquiries, promoting and resisting development on greenfield sites outside settlement boundaries. So we've drawn together our collective experience and identified three common themes that occur in these inquiries and applications. And broadly speaking, those are heritage impacts, landscape and visual impacts, and planning policy considerations. There will be an opportunity to ask questions, and I'd encourage you to put those in the Q&A box, and we'll tackle those at the end if they haven't been answered by the presentations already. Jonathan will be dealing with landscape and visual matters. Rowan will be dealing with planning policy matters, and I'll start off dealing with heritage effects and how those should be considered. So this is, broadly speaking, what we had in mind. So a undeveloped greenfield site, probably in an agricultural or pastoral use on the edge of a small to medium-sized settlement. And typically one or two fields away will be a heritage asset, commonly a church. And usually that church is listed. And so I'm going to be dealing with three things. First of all, what are the key questions to ask yourself or your heritage consultant when you're either promoting or resisting a proposal on a greenfield site that may have a heritage asset nearby? Secondly, what are the key sources of advice and guidance to help answer those questions? And thirdly, the consequences for the overall planning balance. So first of all, key questions to ask. The first thing to ask yourself if you've got a heritage asset nearby is, what is the significance of that asset? Then to ask yourself, is the development in the setting of that asset? If it is, ask yourself, how does that setting contribute to the significance of the asset? And finally, how will the development affect the ability to understand or appreciate the significance of the asset? So, key sources of advice and guidance. First of all, on significance. Well, we know that heritage interest comprises archaeological, architectural, artistic, or historic significance, and significance can be drawn from one or more of those contributing factors, and that we're told that from the NPPF and PPG, but we're also told that evidential, communal, aesthetic and artistic value can contribute towards significance, and that comes from the Conservation Principles Historic England guidance, which predates the framework. I am told that there is a move by Historic England to synthesise the framework terminology of significance with the slightly older Conservation Principles terminology of value, and that would be very much helpful. So sources of significance, where do you go to find out what are the sources which go to contributing to the heritage asset significance? Well, the first place to start with a listed building is obviously the list description, and for a conservation area appraisal, if there is one for a conservation area, but First of all, these documents are unlikely to be exhaustive of the significance of an asset. And secondly, there may not be a conservation area appraisal, or for an older listed building, a particularly comprehensive list description. So if you're a developer promoting a site near a heritage asset, you should be prepared in line with the framework to produce your own, quote, proportionate description of the significance of that asset and how the development will affect the ability to understand or appreciate that significance. And if you're a local planning authority, the framework tells you that you should be asking developers to produce such a proportionate assessment in order to assist you in discharging your conservation duties. Second thing then, well, what about setting? Well, we're told by the framework that the setting is the surroundings in which a heritage asset is experienced, and that may be positive or it may be negative. And that in heritage terms means it may either better contribute to our ability to appreciate and understand an asset, or it may obscure our ability to do that. Broadly speaking, where there is a visual connection between the proposed development and a heritage asset, that's highly likely to give rise to a setting relationship. But very important to remember that, as a matter of principle at least, an absence of a visual connection, a direct visual connection, does not preclude land from falling within the setting of a heritage asset. And that is the Steer case in the Court of Appeal, although on those facts, of course, the inspector was not wrong to find the particular land in that case not within the setting. Setting can be important, and a picture that I do like to refer to is this one, showing the walkie-talkie building affecting, I would suggest, the setting and ability to appreciate the design aesthetic of Tower Bridge by putting its mass and bulk right in the centre there from viewed from the east. So what about contribution? Well, if you remember nothing else from this section of the talk, I would suggest this is the most important aspect, because in my experience, it is this question which usually determines the heritage issue in any appeal. How does the land contribute, if at all, to the heritage significance of the asset? Good place to start, Historic England Good Practice Advice Notes, commonly known as GPA 2 and 3. And as I say, it's often the critical question, and it's step 2 within the framework set out in GPA 3 that's often the key battleground at a contested appeal. And that talks about things such as the physical surroundings, the intangible associations, patterns of use between the development site and the particular heritage asset, noises and smells, slightly less commonly an issue, but views, very commonly an issue, both towards a heritage asset and how a development proposal may affect the ability to see it visually, but also views from a heritage asset and how the development proposal may well affect that. Effects then, well, they may be substantial or less than substantial, and the framework, as planning policy stands at the moment, requires an assessment about whether it falls within one or other category. Substantial harm is a very high hurdle, and I would suggest an especially high hurdle for setting cases. I've not seen an example of an inspector, less the Secretary of State, finding substantial harm arising from development within the setting of a heritage asset. Not to say it's not possible, and certainly one could imagine if there were a particular designed view or relationship between two heritage assets that have been particularly conceived in part of its design, and a development were to interrupt that relationship in a substantial way, that might well be in the category of substantial harm. But broadly speaking, most setting cases are probably going to be in the less than substantial harm category. But do remember, of course, that that is a wide category covering everything from negligible but present harm all the way up to simply one down from substantial harm. So it might well be helpful, and it would be my advice, whether you're promoting or resisting, to set out some gradation of harm to assist the decision maker, be it inspector or the planning authority, understand where this particular development you say sits on the scale of harm. Well, what are the consequences for heritage harm in the overall planning balance? Well, we're told that any level of harm should carry great weight, and that really is the corollary of the policy that says that any harm should require clear and convincing justification. Those policies in the frameworks, those paragraphs in the framework, we are told by the courts, if you follow them through, you will likely have discharged your duties under the legislation if you're a decision maker. And so there shouldn't be any extra task that's required. And the Court of Appeal in a case called Mordew tells us that if you work through in a sequential and methodological way the policies in the framework on heritage, you are likely to have discharged those statutory duties. One of the issues that's arisen over the last 18 months, 2 years or so is, well, what do you do in a case where you've got both heritage benefits and heritage harm? And we now have a resolution to this in the Court of Appeal's decision in Bramshill, which is that there's no requirement to undertake an internal heritage balance to determine whether there is so-called net harm, i.e. you don't have to ask yourself as a decision maker, inspector or planning authority, whether the benefits to heritage outweigh the harms to heritage before you then go on to the overall planning balance. However, it is open to a decision maker to adopt that approach, and very helpfully last week we had the Secretary of State's decision in the Bell Foundry case, where he accepted the advice of his inspector and performed such an approach. So he effectively asked whether the heritage benefits outweighed the level of heritage harm. He found that they did, and therefore there was no net harm that he needed to go on and balance in the framework. Do remember, whichever way you come out, if there is harm as an outcome of the process, heritage harm, even a negligible amount, the courts have told us, engages the policy consequences in the framework. And what are those consequences? Well, you must undertake either the paragraph 195 for substantial harm or 196 for less than substantial harm balance. Commonly 196 for setting cases, as I would suggest, they are unlikely to fall into the substantial category. And at 196, the obligation is to weigh the public benefits of the scheme as a whole. So that's not just heritage, that might include contribution to housing, land supply, or landscape benefits, or whatever they might be, against the heritage harm, taking care, of course, to give great weight to that harm. And that tells you, that balance, 195 or 196, that tells you whether the tilted balance, on which Rowan will tell you a bit more about in his section, applies in a relevant case, because as we know, and just to foreshadow his talk, that the tilted balance applies in a situation where relevant policies that are most relevant are out of date. However, that tilted balance may well be disapplied if there is a clear reason for refusal in the framework, and heritage is one of those expressed as a clear reason for refusal if you fail that balance. Where a scheme fails the balance, well, that's a powerful material consideration weighing against the scheme. So not only would it disengage the tilted balance if it had been engaged, but it would also weigh heavily against the grants of planning permission. And that's all I wanted to say on heritage. Now hand over to Jonathan, who's going to talk you through landscape and visual matters. Jonathan.
Well, good morning and greetings from the amber zone of the French Hautes-Pyrénées, which I'm broadcasting from or webcasting from this morning. The assessment of landscape and visual effects of development is not restricted to greenfield sites, but it's almost always, in my experience, a relevant consideration in greenfield development and is often a reason for refusal of planning permission. Next. This is not a view of the Haute Pyrenees. This is a view of the Derbyshire Peak District, which was the first ever national park designated in 1951 in the UK. The UK has a long history of cherishing the extraordinary diversity of our landscapes, and their recognition of their importance in the 18th and 19th century and their intrinsically natural beauty was reflected in the great parkland settings for the great houses of the period. Became part of the formal planning process only in the mid-20th century, more or less the same time as modern planning law came into force after the Second World War with the Town and Country Planning Act. It was different legislation in 1949, which I'll be referring to in a minute, which brought us the national designations of national park. Next, please. The overview of today, I can only hope to scratch the surface of the subject. Happy to answer questions, but the objective of this part of the webinar is to review the continuing evolution of the approach taken to the handling of landscape and visual effects in the planning process. Next. Next slide, please. Can I start by introducing to the a volume which you may well have if you're dealing with Greenfield sites and you're dealing with landscape. This is the document that you need to refer to, and it's used by landscape architects, planners, barristers. This is the guidelines for the landscape and visual impact assessment, sometimes the acronym GLAVIA, and this is the 3rd edition. It's published by the Landscape Institute. It was radically revised from the 2nd edition, and it seeks to provide a greater degree of objectivity and transparency to the dark arts of landscape impact assessment. Its guidance is not mandatory, but it is recognized by the courts as best or good practice. Next, please. Now, this introduces a matrix or matrices which pick up on which is for the assessment of significance of effects, and it identifies factors such as susceptibility to impact, the value of the landscape, and looking at those two together creates an assessment of sensitivity. And then you've got, you're looking for the magnitude of change. You look at the scale of the landscape, but also the scale of the development in relation to that, the duration of the change. So is it going to change? Is planting, is mitigation going to come into play? And reversibility, is it going to be a one-way development? And certain developments like quarrying, for example, mineral extraction are mitigated after the minerals have been extracted. And taking those together, you create an assessment of magnitude, and then putting sensitivity and magnitude together gives you the final objective, which you want to identify, which is the significance of the effect. Explicit slide, please. Now, there's no rigidly applied formula, but the starting point in every landscape or visual impact assessment is the assessment of landscape character in a landscape character assessment, an LCA. And that establishes the baseline. It identifies the important elements and features, the key characteristics, and it provides the basis for attaching a value to the landscape. And this is a theme which I'm going to be developing during this brief submission to you today. It also identifies landscape receptors, and receptors can be two parts really to the concept of receptors. First of all, it's the receiving landscape where development is proposed, but it's also the people able to view the proposal and that might be affected by the change. And so you're identifying what is affected, i.e. the landscape, and who is affected. There is this key interaction between the development proposal and the landscape receptors. Next slide, please. Now, this key concept of landscape value is not to be directly confused with the concept of valued landscape, which is a policy description. And it arises from the national framework, National Planning Policy Framework. And there is effectively a landscape policy hierarchy, which you find in the framework at 171. In the planning process, plans need to distinguish between, and these are my emphases in this slide, this is what 171 says, distinguish between the hierarchy of international, national, and locally designated sites, and allocate land with the least environmental or amenity value where that's consistent with other policies in the framework, and take a strategic approach to maintaining and enhancing habitats, networks of habitats and green infrastructure, and plan for the enhancement of natural capital at a catchment or landscape scale across local authority boundaries. For obvious reasons, local authority boundaries do not necessarily represent the identification of a particular landscape. Next slide, please. International importance, quickly go over this. World Heritage Sites, we're all familiar with examples of that: Stonehenge, the Jurassic Coast, but also the Three Graces, for example, on the quayside, on the River Mersey quayside in Liverpool. And they are of international importance for the conservation of our cultural and national heritage. I also mentioned here the European Landscape Convention, to which since 2007, the UK has been a signatory, which promotes the protection, management and planning of European landscapes. And that's organised normally through DEFRA and Historic England. The next slide, national designations. National parks at the very top of the hierarchy. Two functions that they have. They're designated through the National Parks and Access to Countryside Act 1949, but in fact the legislation is amended by the 1995 Environment Act. But they have these two functions, the first being conserving and enhancing the natural beauty, wildlife and cultural heritage of the area that's identified. And secondly, there is a recreational function. Can you move on to the next slide, please? And that is that they afford open air recreation, having regard both to their character and position in relation to centres of population. Now, these two things can interact, of course, and it is important to be aware that the conservation of natural beauty is now clearly given priority in the Environment Act over recreational use, applying what's called the Sandford principle. Next slide, please. Then there's areas of outstanding natural beauty. All planners will be familiar with these. And there is a particular duty, statutory duty, under Section 86 of the Crow Act, which is that in exercising or performing any functions in relation to, so as to affect land in an area of outstanding natural beauty, a relevant authority shall have regard to the purpose of conserving and enhancing the natural beauty of the area of outstanding natural beauty. So there's a duty on decision makers in making planning decisions to have regard, this term which appears in heritage legislation as well, to have regard to the purpose of conserving and enhancing the natural beauty of the area of outstanding natural beauty. Next slide, please. Now, below that level, there are no statutory designations in relation to landscapes, although there are often local landscape designations. But policy has waxed and waned in relation to local designations. And until recently, the consensus was that valued landscapes were to be identified through the application of certain factors, identification of certain factors that are in one of the boxes, box 5.1 of the guidelines published by the Landscape Institute. And those factors are identified: landscape quality or condition of the landscape, whether it's been damaged by development or other activity or operations; scenic quality, the rarity of it, is it an unusual or special in some way, or is it particularly representative of or typical, quintessential, if you like, to the landscape description? Does it have conservation interest? And that could be either natural or built conservation interest. And very often in AONBs, you find that the designation will wash over villages or buildings of historic and architectural interest. And then recreational value. Does it offer something special in that way? And then perceptual aspects. Is it valued by its community? Is it valued by those who visit it? And then it's associations, and that can be associations with famous people or events or individual occasions. Thank you. Next slide, please. Now, what has tended to happen in the past is that the two terms, landscape value on one hand and valued landscapes on the other, have been to some extent elided, and for that reason, box 5.1 was treated as being the basis for identifying whether in any individual case the landscape that's affected was a valued landscape for the purposes of the NPPF. A landscape value is an assessment of the relative value of the receiving land, the receptor, attached to different landscapes by society. And that may be differently valued by different stakeholders. Now, what the NPPF in its original form states, it's paragraph 109, this is the 2012 edition, it states that the planning system should contribute to natural and local environment by protecting and enhancing valued landscapes. And that was very often taken as being the defining, if you could show that your landscape was a valued landscape within the meaning of paragraph 109 of the framework, then you were well on the way of showing that there was a substantial ground for objection to the development. On the other hand, if you were developing the land, you wanted to show that it was not a, in quotes, valued landscape. And that approach of taking you through the factors in 5.1 was the means by which that was done. Now, the question now arises whether there has been a change of policy. Could you move on the slides, please? Now that sets out the latest version of 170A in the framework. Planning policies and decisions should contribute to and enhance the natural environment by protecting and enhancing valued landscapes and so on. Next slide, please. But has there been a change in the policy? Because we now have, because we have in paragraph 171, this process by which landscape value is identified by designation through the local plan process. The question is now arising, is there a change? Has there been a change to the policy and a requirement for designations to fall within the term valued landscape and therefore have the effectively the requirement to protect that natural beauty or enhance the landscape? Has that changed? And Flitch Way decision in Essex, the policy was construed in the following way, and I'm going to quote from this because it's an important quote. The revised framework has clarified the position. Valued landscapes should be protected in a manner commensurate with their statutory status or identified quality in a development plan. A straightforward reading of paragraph 170A does not lead to the view that there are other categories of valued landscapes, in other words, which are not statutory designated or identified in a development plan. In that case, the inspector just concluded that as the appeal site does not meet the requirements of paragraph 170A, I find that it's not a valued landscape. So you'll see that what, in that case, the inspector has done is to revert to designation as being the basis for valued landscape, rather than carrying out the box 5.1 approach to it. Now, that was a decision that was taken in 2019. More recently, in fact, last week, landed on my doormat the latest edition of the Journal of Planning and Environment Law, which my colleague Dr. Ashley Bowes edits, you'll find if you look at the cover. And within that is a decision concerning Red Row Homes. And if you want the page number, it's at page 759. But the key paragraph within that is on page 765. And in that case, the inspector does not appear to have taken the same approach as in the Flitch Way appeal. Could you move on, please? Next slide, please. And it says this: the inspector concluded that undoubtedly this is an attractive area of countryside that's generally representative of the settled landscape type. Local people, that should be clearly hold it in high regard. However, I cannot agree it's sufficiently intact or visually apparent to be of regional importance. So you see there are a whole series of factors considered by the inspector, and on that basis, not because it's not designated or it is designated, I do not consider that it's a valued landscape within the terms of paragraph 170 of the framework. So you've got those two approaches, and where we find as barristers, those kind of two different approaches, inconsistency effectively between the decisions of senior inspectors in appeal decisions, we start to, our legal antennae twitch because we don't know how the courts are going to treat the change in wording in the policy in relation to valued landscapes. Because as the inspectorate's approach does not appear to be settled, this is almost inevitably an issue which is going to come before the courts at some point in the future. So I leave you with that dilemma in considering if you're involved in these decisions, considering whether or not your site is one which is or is not a valued landscape. And we will see how the law develops.
Thank you, Jonathan, very much for that. And now to Rowan to draw the threads together in the planning balance to examine some of the planning policy issues that arise from settlement, development outside settlement limits. Rowan.
Thank you very much, Ashley. Thank you very much, Jonathan. Hello, good everyone, and thank you very much for joining us. I'm going to talk very briefly about some of the planning balance or planning policy issues which are likely to be relevant in cases involving developing greenfield sites. Turning to the first topic, please, Ashley, which is one which no doubt you'll be familiar with, the presumption in favour of sustainable development. The achievement of sustainable development is, as paragraph 7 of the NPPF states, it's the purpose of the planning system. And by the NPPF, the planning system then includes a presumption in favour of sustainable development, which is said by paragraph 10 to be at the heart of the framework. So whilst the presumption in favour of sustainable development has impacts on plan making, more importantly today I'm going to talk about and focus on its impact on decision taking. So how does the presumption in favour of sustainable development impact on decision taking? Well, you'll note that it means that where there are no relevant development plan policies, or those policies which are most important for determining applications are out of date, and that includes situations where there's a 5-year housing land supply cannot be demonstrated, or the HDT indicates delivery is substantially below the requirement for the previous 3 years. Then, if those conditions are engaged, then permission should be granted. and that's unless the provisions of 11D1 or 11D2 of the NPPF are engaged. And I'm going to come back to an analysis of those sub-paragraphs in due course. However, the point that I want to make, having kind of quickly whizzed through that particular paragraph, the point I want to make, just going over the slide, is that before we approach those questions, the first issue that an applicant should consider, and it's on the next slide, please, Ashley. The first question that an applicant should consider is that which is in the preceding paragraph of 11 of the NPPF, that's 11C, which states that development proposals according with an up-to-date development plan should be approved without delay. So the first critical question should always be, does the proposal breach the development plan? Because if it doesn't, then the proposal should be approved without delay. A key case that I want to flag on this point is the recent Court of Appeal authority of Corbett, in which the court highlighted that simply because a proposal doesn't accord with some or even several specific policies, that doesn't mean that it's at odds with the development plan for the purposes of paragraph 11C. So you can envisage a situation in which there is some conflict that's relatively minor, and that paragraph 11C prevails such that your proposal could still be approved without delay. And the court reached that conclusion, the conclusion in Corbett, by considering the following steps. First, by section 38(6) of the Planning and Compulsory Purchase Act 2004, authorities are required to determine planning applications in accordance with the development plan unless material considerations indicate otherwise. And in conducting that exercise, authorities are required to analyse whether a development accords with the development plan considered as a whole. And then the second limb, the second step, development plans, as we know, often include policies which pull in different directions. And it's therefore unlikely that any development could satisfy all policies such that it would be a totally harmonious proposal, a proposal that included no conflict to any extent with the development plan. But what is important as part of that second limb, what is important is that authorities apply their planning judgment to assess the extent of any breach and the importance of the policy that may be breached in assessing, in light of that assessment, whether the proposal is in accordance with the whole development plan. And then thirdly, and this is a point that I'm sure you'll be very familiar with, recognising that that judgment, the assessment of the nature, extent and importance of the policy is itself an exercise of an authority's planning judgment. That planning judgment is only reviewable or challengeable where it is itself irrational or perverse. So drawing all of that together, even where policies pull in different directions, they must be read together as a whole, or read together as far as possible. The key question is whether the proposal accords with the development plan considered as a whole, and whether or not it does will depend on the extent of the breach, the importance of the policy, and the extent of the harmony with other policies in the development plan, which in turn necessitates the application of planning judgment by an authority. And just recording or repeating what I said previously, that application of planning judgment will not be challengeable unless it is irrational in the public law sense. So I'm just going to skip over the next slide, in which I was going to further analyse Corbett, because I'm just slightly conscious of the time. Moving next to, yes, here we go. So if an application conflicts with an up-to-date development plan, then there is a presumption against the scheme. That's paragraph 12 of the NPPF. So if there is a breach, then the applicant should consider whether the tilted balance, i.e. that's paragraph 11D of the NPPF, is engaged, because that will then again commend granting permission. So the key questions, preliminary questions, or routes to the tilted balance in 11D are whether there is no relevant development plan policy, or whether there are no relevant development plan policies, that's trigger 1, or whether the most important policies for determining the application are out of date, that's trigger 2. So I'm going to deal with trigger 1 first. Again, reminding you that's when there are no, or whether there are no relevant development plan policies. So how do we understand the phrase no relevant development plan policies? The question has been helpfully addressed this year by the Court of Appeal in the case of Newman. You have the authority on screen, in which the court found that the phrase no development plan policies in the NPPF describes the situation where there is no policy in the development plan that is relevant to the decision whether the application should be granted or refused. And in that context, what relevance means is policies or policies that have a real role to play in the determination of the application. However, it's not a requirement that the policy or policies should on their own be enough to enable the decision maker to grant or refuse the application. So relevant doesn't mean determinative, and the first trigger, the first route to the NPPF can't be activated if there is a relevant policy in the local plan. So at first blush, it seems like it's going to be quite a difficult trigger to pull, the first trigger, because the threshold for relevance is relatively low, and the effect of any relevant policy will be that this route to the tilted balance is not available. However, I would note it's not the case that all policies will be relevant to the issue being determined. In Newman, the court stressed that mundane policies, policies of general application, policies that it seems to kind of strain language to say are relevant to the issues being discussed. Those kind of policies of general application will not be relevant for the purposes of avoiding the tilted balance. So what does it mean in practice? I think probably approach the development plan benevolently with the concept of relevance in mind. Consider whether there is any policy which has a real role to play in the application. And if the only policies which have a bearing on the proposal are very general, vague, or mundane in application, then there could be scope for an argument that there are no relevant development plan policies, and that trigger, that route to the tilted balance is engaged. But turning then to trigger 2, whether the most important policies are out of date. The first step is to consider which of the policies in the development plan are most important for the purposes of determining the application. And then the next issue is to consider whether those policies accord with national policies in the framework, and whether they're out of date. And something that I think is important to note is that whether they're out of date or not, it doesn't necessarily follow from the fact that they are part of a time expired plan, or indeed within a plan that has not yet expired. The requirement is also for policies to be out of date, and the fact that there is maybe one or several out of date policies will not necessarily justify the tilted balance on its own. I want to just go over the slide to refer to the correct approach set down by Mr. Justice Dove in a case called Wavendon Properties in 2019. And he basically repeats what I've just set out already. The first step is identify the policies which are most important for determining the application, then examine each of the policies to see if they're out of date. And then the third important step is to assess the policies overall and determine whether standing back they're out of date for the purpose of the. Just moving on to the next slide, please, to another key question. Yes, if there is no development plan policy, or the policies which are most important for the determining the application, if those policies are out of date, is an inspector obliged to disregard relevant policies of the development plan when operating the tilted balance? So, in short, is an inspector obliged when operating the tilted balance to only have regard to the policies within the framework, or are development plan policies relevant? The answer is that development plan policies can be relevant and may be considered when applying the tilted balance. And that's a case, a Gladman case from 2020. I've set out the judgment in full there, but I'm not just going to read it out. You'll note that the key aspect of the judgment is that paragraph 11D refers to policies within this framework. However, the Court of Appeal in Gladman found that policies in this framework can be construed in a way that's wide enough to relate to policies in the development plan, and also added that sometimes it makes good sense to do that because of the relationship between the NPPF and development plan policies. But again, just turning over the slide, please. Thank you. Whether and how policies of the plan are taken into account when operating the tilted balance is again a matter of planning judgment and exercise of planning judgment, which will depend on all the circumstances in hand. So again, that is an application of judgment that will only be reviewable in the event of irrationality or perversity, as I indicated before. Thank you. Ashley, could I have the next one, please? Now, another question which is relevant to the application of the tilted balance is whether weight, and what weight indeed, may be attached to policies which are out of date. There's helpful guidance on this question in the case of Suffolk Coastal, which I'm sure you will know that both Ashley and Jonathan were instructed. The key takeaway point is that policies which are out of date in this context do not become irrelevant simply by reason of being out of date. However, what is clear is that the weight attached to these policies is not fixed by the NPPF, and it remains a matter of judgment for the decision maker. The court has suggested some factors which will guide this discretionary exercise, and weight will depend on the nature of the policy, the extent to which it enables or frustrates the supply of 5-year housing land, the interest that the policy is trying to protect, i.e. why it's restrictive, whether it's in accordance with the NPPF, and of course the impact of the policy being breached. Just turning over to the next slide, please. Just one moment, yeah, perfect. Yeah, so that's another case, Hallam Land, which effectively I've already articulated the principles by reference to Suffolk Coastal, but it's another case that you might have regard to when you're considering this question. Just moving on to the next one, I just want to cover this very briefly. This slide concerns policies which seek to be very restrictive of development outside development boundaries, and it has the question of whether a policy is out of date or not in mind. Such policies which are very restrictive of development outside settlement boundaries, are at risk of being out of date by reason of being at odds with the updated NPPF. They have the authority there, Telford and Rankin, because the new NPPF, replacing the 2012 version, does not include a blanket protection of the countryside for its own sake. So that's something to consider, whether a policy may be regarded as being in conflict or not in accordance with the NPPF, and therefore that may sustain an argument that it's out of date if it tries to provide a level of protection outside the countryside that is blanket and doesn't take other factors into account. So just going over to the next slide, please. There's another key issue. It's the final sort of main issue here. What about cases in which policy must be breached in order to maintain a 5-year housing land supply? They're typically being referred to as broken policies. For example, where a policy inhibits development in the open countryside or something similar, and has been treated as being outweighed a number of times by a local authority, outweighed by other material considerations, and that approved developments, which effectively have circumvented the application of that policy, are being counted in the local authority's 5-year housing land supply. Does that mean that the policy should be given very little weight, in essence, because if they were applied fully and consistently, they would lead the council to fall short of its housing need? Now, the preliminary answer from the Court of Appeal in a case called Daventry has been no, essentially because it's open to a local authority to be persuaded on the facts of each application that the application was sufficiently exceptional, i.e. that it could the relevant policy, restrictive policy, could be departed from to justify development contrary to the relevant policy. And that this itself was a lawful operation of planning principles, and so the Court of Appeal found in Daventry that the policies were not broken. But more recently, see Mr. Justice Dove's comments in another Gladman case, this time from 2019. Firstly, and I've highlighted it in pink, he observed that in Daventry, Lord Justice Sale's observations were obiter, not binding. And secondly, he went on to explain that all Lord Justice Sales was suggesting in that part of his judgment in Daventry was that it did not necessarily mean that because permission had been granted in breach of a restricted policy, that the policy was out of date. But it did leave the door open for the possibility of such a conclusion to be reached on a case-by-case basis. It follows, whilst it's not the case that simply because a policy is frequently being departed from or found to be outweighed by other factors to allow building in the open countryside, that it's necessarily broken and out of date. Analysis of the available evidence on its performance and consistency with the framework can be taken into account in assessing whether it's up to date, and a decision whether it's broken and therefore afforded lesser weight remains, in my view, an option open to a decision maker depending on the facts of the case. So I think it's important to heed the remarks from the Daventry case, but also to see those remarks through the lens of Mr. Justice Dove's comments in Gladman. I just want to make very briefly a few very short points on issues which is helpful to consider to ensure that your development proposal is as persuasive as it should be. The overarching point is to ensure that you've demonstrated clear evidence of the benefits of your scheme. If the applicant's not a house builder, ensure there's material evidence to demonstrate delivery, indicate how the scheme will actually contribute in practice to housing land supply, that you'll be able to get houses built, including evidence of house builder involvement, if there is any, the likely timescale for completing a project with a buffer, if that's appropriate, and evidence of track record of delivery. Second point, use the DEFRA calculator, clearly evidence the biodiversity benefits of a scheme. And thirdly and finally, identify the housing needs of the relevant authority, for example, tenure types when considering affordable housing, and demonstrate how the development will contribute towards meeting that target. The same is true in relation to any open space requirements which are to be delivered as part of the scheme. So that's, again, a bit of a whistle-stop tour of quite a difficult area. If you have any questions, please, I'll be happy to answer them, but I'm just going to finish there and hand back to Ashley. So thank you very much for listening.
Thank you very much, Rowan, for that very interesting canter through the planning policies. I don't have any questions in the Q&A, so I'll take that as we've answered everything that you could possibly want to know about the development of Greenfield sites. But to say, obviously, we would be only too happy to pick up any questions arising from our presentations with you privately outside our session, and that the slides and recording should be available in due course on our website. So unless anybody does have any questions that they'd like to ask now, that's triggered a question. I will see if I can open that question. It won't let me open. I shouldn't have asked. Hang on. Well, that's tantalising. Sam, if you're there.
I am.
Hi, sorry, I can't open the questions that are in the Q&A. Are you able to open them and just email them to me?
I'll send them over via email, Ashley. 2 seconds.
Thanks very much.
We've now got 3 questions.
Yeah, so I'll read them out. So the first one, I won't mention who they're from because I understand that gives rise to data protection issues. But the first question is, because out-of-date policies are no longer just policies that relate to the supply of housing in the absence of a 5-year land supply, would it be likely that, I think that's built up area boundary policies would ever be considered up to date? I would doubt it, would be interested in your comments. So probably one for Rowan, whether a built-up area boundary policy could ever be up to date. Rowan, did you want to take that? I'm happy to answer it myself. I mean, I think to answer your question, thank you for it. I think certainly they can be up to date, and it largely turns on whether the policies are working to deliver the overall strategy. And that, broadly speaking, will be if there is a 5-year land supply, for example, then built-up area boundary policies ought to be afforded full weight, because the strategy to which those boundary policies are effectively the policeman are working. And so why should you reduce the weight to them? I think would be my view. I don't know, Rowan, if you wanted to add anything to that.
Yeah, I agree. I think probably the extent to which they can be, the extent of the weight that can be afforded to them really depends on the factual circumstances, what's going on the ground. The extent of the shortfall in the 5-year housing land supply will also be a fairly critical issue in that regard. But I don't see that they could never be considered up to date. It seems open to me that they could be. But again, it'll be a matter of planning judgment for the authority.
If we just think about it, I suppose it would be very frustrating for a local authority if they've been through the time and effort of a local plan, which government policy for the last 50 years has been to encourage authorities to have, where they carefully set out where development's to go, where the spatial strategy, how it's to work, this hierarchy. If you could then just depart from that and build wherever you liked. And in order to stop that adverse situation arising, you presumably need settlement boundary policies that have some teeth. So the second question is, you referred to the Suffolk coastal case, but that precedes the current NPPF. The new NPPF does not refer to policies for the supply of housing. Can you clarify? Rowan, do you want to take that question?
Well, I had rather earmarked that question for you, being that both you and Jonathan have appeared in the Suffolk coastal case.
Sure. Well, I think the answer is that's absolutely true. The case was about, in essence, what was the meaning of the phrase policies for the supply of housing. But in answering that question, Lord Carnworth explained that really the critical question was the weight that you attach to conflict with policy. And that may well be influenced by the fact that there wasn't a 5-year land supply, and therefore policies which were designed to support a particular strategy that wasn't working because it wasn't delivering a 5-year land supply shouldn't be afforded full weight. But he also said, well, that goes a bit broader. For example, I think he uses the example of employment land policies. He says, well, if you had a policy safeguarding a particular site for employment uses, but the employment need had radically changed or altered in a particular way such that that site should no longer be preserved for that particular use, well, that would also then bear on the conflict with that land allocation policy. And effectively what he was saying was to look at it through the sort of narrow linguistic lens of what was and wasn't a policy for supply of housing, missed the point, and that I think 11 lawyers in that case had sort of got it wrong, and that really that you should step back and look more holistically and in a more nuanced way about what the particular land use policy is seeking to do. Is that particular policy objective a current one, or is it out of date? And if it's out of date, well then probably it shouldn't carry full weight. I don't know, Jonathan, do you want to add a thing about it? Obviously you had a very active role in that case as well.
Yeah, well, I think that's you've said it correctly. I mean, it's actually quite interesting to look at those two questions side by side, because the first one is concerned with whether you should treat a built-up area boundary, a settlement boundary, as being out of date because there is no 5-year housing land supply. And in that case, it would be very case sensitive in my view, because it may well depend on the reason why the boundary was set in the particular position that it was. If it was set on that in its particular location in order to provide sufficient additional land to be allocated in order to meet a 5-year housing land supply at that part of the settlement boundary, that is one case. But there is a different case that applies if it is the settlement boundary is there to mark the edge where there is a clear edge to the to the urban area or the settlement area, and a landscape which is to be protected on the other side. So the question of whether or not a policy is out of date is not simply a question of whether or not there's a 5-year housing land supply. And if it is, so be very careful with what is the reason for the settlement boundary to be treated as being in a particular location. Then getting to the questions that arise from Suffolk Coastal. One thing that's important from, I mean, Rowan rightly identified some of the points from the Court of Appeal's decision in the Suffolk Coastal case, because that case went to the Supreme Court and has to be read in the context of the Supreme Court's judgment too, where several of the findings in the Court of Appeal were treated differently in the Supreme Court from how Lord Justice Lindblom had treated it in the Court of Appeal. But the change in the policy does mean that the precise words that they were examining in the Suffolk Coastal case are no longer part of the plan, but the principles, I would say, in Suffolk Coastal are still highly applicable. And one sees Suffolk Coastal being applied on a daily basis in decisions of the planning court and treated as good law and not out of date.
Yeah, and that's absolutely right. I think one of the things that case illustrated is that sometimes, especially with a planning specialist court, the issues can get quite siloed, and sometimes it does need to go up to the Supreme Court to sort of settle something from first principles. And Suffolk Coastal is probably a very good example of that. Reprotect, probably about 10 years ago, was another good example. I think it's another one of your cases, Jonathan, about where estoppel had sort of arisen as a planning law concept, and the House of Lords said, no, that's not right. And the final question we've got is, how do you advise a local planning authority can conclude what is or isn't up to date in the absence of a 5-year housing land supply? Would there be any reason why a positively worded policy dealing with the delivery of strategic allocations would be out of date in these circumstances? Well, I think there's quite a straightforward answer to that first part, which is that the new framework deems effectively the policies to be out of date if there is not a 5-year land supply or you fail the relevant part of the housing delivery test. So that answers that simple part of the question. But I think that the more difficult part is then, well, that engages the tilted balance. But as Rowan said, well, you can take into account the conflict with development plan policies in the tilted balance. So how much weight do you give them in the tilted balance? And you've identified there, what about a positively worded strategic policy about delivering a strategic allocation? Well, that might be a circumstance where the tilted balance is engaged. So you're asking yourself whether the adverse effects significantly and demonstrably outweigh the benefits. But in performing that balance, you attach significant weight to a conflict with that strategic policy, because that policy is consistent with national policy. The shortfall is likely to be remedied by the bringing forward of that scheme, and therefore a conflict with the strategic allocation might well be something which gains significant weight in determining the tilted balance on application of a particular planning application. So I think the 2 points are, well, one, when you don't have a 5-year land supply, automatically it's deemed that the relevant policies are out of date, because that's what the framework says at para 11 footnote 6. But how much weight you give those policies in the application of the tilted balance is a question of judgment, and that will turn on questions such as, well, how consistent are they with the framework? How big is the shortfall? What are the steps the local authority seeking to put in place to make up the shortfall? So I hope that answers your question. Is there anything else, sorry, Rowan and Jonathan, you wanted to add to that?
I would just add to that the second part of that question suggests that when a policy is out of date, that it's somehow beyond consideration. That's not really, that's not the thrust of my talk. I think the answer to the second point, as you said, Ashley, is that the policy could be deemed out of date, but that designation doesn't necessarily rob it of significance and potentially extreme significance in the course of determining the application, simply because it is deemed out of date.
That's right. That's a crucial point. The fact that it's treated as out of date as a matter of application of footnote 6 in the NPPF doesn't kick that policy out of touch. Or into touch, is it?
I think that's right. I mean, probably
still relevant, and it's still a question for the decision maker as to what weight to attach to that. And the starting point for all of this is section 38(6) of the 2004 Act and section 70, subsection 2 of the Town and Country Planning Act, where you first consideration remains the statutory development plan, and we have a plan-led system.
Absolutely, and I think the way the courts have dealt with the point now is it's probably pretty well settled that if a decision taker, inspector or a local planning authority were to say that a policy were out of date and therefore for that reason alone carried no or very limited weight without considering those separate questions you just asked, that probably would be in the category now of a clear error of law. So I think your points are well underlined by the way the case law has travelled since we first had the first framework in March 2012. So I don't think we've got any more questions. Sorry about the short delay in answering those. I hope those answers were helpful and you found the talk helpful overall. We look forward to seeing you at one of our future talks in the planning team series later on this week and later next month. Thank you very much for joining us. Goodbye.
Thank you very much. Bye-bye.